Ms. Lawson. Welcome to our meeting.
Good evening, Christine Lawson, District 4. That was quite a presentation. Unfortunately, most of it's nonsensical, as was explained in the draft anti-lighting notice that was submitted to all of you last week. So we'll stand by that and we'll reiterate everything said in that draft anti-lighting notice that was contrary to what Mr. Young said. But I have some additional remarks too. One of them is about a draft resolution that appeared on the county website. And it contained a misstatement of facts, and it was actually reiterated by Mr. Young about what happened at the Planning Commission on January 24th of 2023. Now, what your resolution, the draft resolution on the website says is, whereas the Planning Commission conducted its study and review, including holding public hearings and made recommendations to the Board of Commissioners for review and consideration. Now, I know Mr. Stevens was there, so Mr. Stevens knows what happened. The rest of you may not. That's why I submitted a copy of what actually happened at that meeting. So what happened at that meeting is Mr. Hawthorne at the end of the meeting said, I hope everybody understood what just happened. We are not sending a recommendation before the Board of Commissioners regarding changing anything to do with chickens, but to change the ways to accommodate to put people and everybody in areas where they will be today, which is A1. There was no recommendation made to this board regarding the proposed chicken amendment. Now, as I explained in the draft anti-lighting notice that was submitted at the last meeting, an amendment to the UDC must be submitted to the Planning Commission for review and recommendation. Now, Mr. Young pointed out you can come up with your own recommendations, but they still have to go through the Planning Commission. You don't get to skip that step. Now, what the Planning Commission actually did recommend was that you rezone R1 properties that were an acre or more to A1. And what I see in the resolution looks like an effort to try and fix the procedural deficiencies that I pointed out to Commissioner Harris, who's not here today, after the last meeting. Now, Commissioner Harris understood, when I spoke to him, that there was no recommendation made about the proposed chicken amendment. He also cited that the R1 properties be rezoned to A1. And so there was no proposed chicken amendment sent to this board by the Planning Commission. And so that's a procedural problem. And this board has never actually considered the rezoning recommendation that was sent to the board by the Planning Commission to rezone R1 properties to A1. Instead, you tried to move forward on this proposed chicken amendment that the Planning Commission has not recommended. And your proposed resolution does not save you from those constitutional deficiencies that were outlined in the draft anti-lighting notice, but instead it merely adds to the citizens' constitutional complaints against this board. Now, this resolution, in my opinion, appears to be some sort of effort to avoid sending that proposed amendment through the Planning Commission for its review and recommendation, and that may be because the Planning Commission's already said that they're not going to do it. And I have to wonder, the board has pursued this chicken amendment, which is obviously unpopular, and it's made no sense with any of the facts available to the public. And to the extent where surely members of the board have to realize that this sort of course of action will make you unelectable in the future. And now when actions seem illogical, that normally means that something else is going on, something else is driving a person's motives. Now those true motives may not be patent right now. I can think of a couple hypotheticals potentially. Maybe somebody lives in a neighborhood that the covenants are getting ready to expire and chickens may be allowed, and they don't want chickens there. Or maybe they're working on behalf of another interest that doesn't want chickens on the property. Now I would just remind everyone, if that hypothetical happens to be fact, that's a conflict of interest that you don't need to be voting on this. So that's something to consider. Now I would remind the board too that if it becomes necessary for the citizens to pursue legal action, that during the discovery phase of the litigation, the true reasons for the board's pushing of this proposed chicken amendment would undoubtedly come to light, as would all the machinations involved in this year-long odyssey and the board's failure to adhere to the constitutional, statutory, and UDC requirements. Now, during depositions, those involved, including members of this board, would be put under oath and would be required to answer questions regarding their motives and actions. And any wrongdoing that had happened to go on, I'm not saying he did, but I said if he did, it would be uncovered and then it would be referred to appropriate authorities for investigation. Now, I really adjure this board to very carefully consider its course of action, carefully consider your legal obligations under the Constitution of the United States, of the state of Georgia, and under the Catoosa County UDC. And it seems unfortunate that the board and the citizens of Catoosa County seem to be on an unfortunate collision course, and this is not how responsible government should be run. So I thank you for your time and attention.